Thank you very much, Madam Speaker. I'm pleased to rise to speak at report stage on Bill C-7 and in particular with respect to the two very modest amendments that we here in the official opposition have put forward to the legislation, namely to maintain a 10-day reflection period and to extend the reflection period of 90 days to 100 days where death is not reasonably foreseeable. Madam Speaker, both of these amendments are supported by the evidence that we heard at the Justice Committee in what was otherwise a very rushed process. Madam Speaker, it need not have been this way, and it shouldn't have been this way. Madam Speaker, 1 year ago, the Attorney General should have done what we on this side of the House called on the Attorney General to do, and that was to appeal the Truchon decision. That would have provided clarity in the law, and it would have provided Parliament with time to appropriately respond legislatively if necessary. But the Attorney General didn't do that. Instead, he rushed ahead with legislation purportedly aimed at responding to the Truchon decision. Legislation, I might add, that was introduced with very little consultation. But the legislation went well beyond responding to the Truchon decision. The legislation fundamentally changes the medical assistance in dying regime that was passed in this Parliament a mere 4.5 years ago. And in so doing, the Attorney General and the government preempted a legislative review that was mandated by Bill C-14. Now, Madam Speaker, as a result, what we have is a rushed process to deal with a shoddy piece of legislation that recklessly puts vulnerable Canadians at risk. It is why, Madam Speaker, virtually every disabilities rights organization in Canada oppose this bill. Indeed, 72 national disabilities rights organizations wrote to the Attorney General and pleaded with the Attorney General to appeal the Truchon decision. Those pleas fell on deaf ears. More than 1,000 physicians have penned a letter to the Attorney General opposing this bill. The UN Special Rapporteur on the rights of persons with disabilities expressed concern about Canada's medical assistance in dying regime and questioned whether Canada, in fact, was living up to its international obligations under the Convention on the Rights of Persons with Disabilities. Madam Speaker, I will quote Krista Carr, the Executive Vice President of Inclusion Canada, an organization that represents the rights of persons with disabilities, who said this of Bill C-7, quote, "Bill C-7 is our worst nightmare," end of quote. Catherine Frazee, professor at Ryerson University, the former Chief Commissioner of the Ontario Human Rights Commission, and a leading advocate for the rights of persons with disabilities, said, quote, "Our equality is right now on the line," closed quote, with respect to Bill C-7. And she noted that the careful balance between individual autonomy and equality carved out in Bill C-14 had been upended in Bill C-7. Dr. Heidi Jantz of the Council of Canadians with Disabilities said this, quote, "Bill C-7 would enshrine a legal form of ableism into Canadian law by making medical assistance in dying a legally sanctioned substitute for the provision of community-based supports to assist people with disabilities to live. You must ensure that MAID does not weaponize systemic ableism in Canada," close quote. And that is precisely what she said Bill C-7 does. Madam Speaker, in the face of those concerns, right across the spectrum from physicians and experts to persons with disabilities and their advocates, we on this side thought it appropriate that we proceed in a cautious and deliberate way, having regard for the complexity of the issue, the lack of consultation, and the very short time frame before us to consider the radical changes brought forward by the government in Bill C-7. And so, at the Justice Committee, we put forward reasonable amendments, including maintaining a 10-day reflection period, having regard for the fact that people do change their minds, having regard for the feedback that was provided. We put forward an amendment to ensure that there be 2 independent witnesses. When one executes a will, one needs 2 witnesses. One would expect that at the very least there would be a safeguard at least as robust as in the case of executing a will when we're talking about ending one's life. But no, Madam Speaker, this government removed that safeguard. We put forward an amendment to extend the reflection period where death is not reasonably foreseeable from 90 to 120 days, having regard for the fact that it is often not even possible to access palliative care or other supports within 90 days. What good is a reflection period of 90 days if one doesn't have access to alternatives within such a time frame? But that amendment was rejected by the government, and consistent with what the Minister of Disabilities and Inclusion said, and having regard for the horrific evidence we heard of Roger Foley, who was coerced into making a request for medically assistance dying, which he recorded, that this always be patient-initiated so that coercion is limited, and to guard against that. So, Madam Speaker, in closing, let me just say that what we have is a piece of legislation that does the opposite of what the Supreme Court called on Parliament to do in Carter, namely to provide for a carefully designed and monitored system of safeguards. This legislation eviscerates those safeguards, and on that basis is unsupportable. It needs to be defeated out of hand. Thank you, Madam Speaker.